Simple wills. A brief overview. A will is a legal document which is signed by a will maker and controls the distribution of property upon a person's death. A will allows certain assets to be gifted to specific beneficiaries. Only assets which are owned personally are controlled by a will. Assets contained in super funds and family trusts are not owned personally and need to be considered separately in any estate planning scenario. Simple wills are a good option for individuals with uncomplicated estate planning requirements. Testacy and intestacy. Testacy refers to the existence of a valid will. Intestacy occurs when no will exists or when a will is deemed to be invalid. The will maker. The will maker is any individual who has made a will. The correct legal title for a will maker is testator, male, or testatrix, female. The executor is named in the will and is responsible for carrying out and managing the estate of the will maker upon their death. The executor should have knowledge of the law, accounting, and be familiar with the taxation obligations of a deceased estate. Being an executor is a time-consuming and demanding position. Duties of an executor include locating the original valid will, assisting with funeral arrangements, notifying and contacting beneficiaries, and advising banks, Centrelink, and other relevant organisations of the death. The executor should also be equipped to handle day-to-day tasks, such as the care of pets and having mail redirected. The executor will need to apply to the court for a grant of probate. Third parties can be engaged to perform the duties of an executor. Each state in Australia has a public trustee office which specialise in administering estates. Engaging a professional can help to ensure the smooth and speedy administration of the estate. The beneficiary or beneficiaries are named in the will and receive all or part of the estate. Beneficiaries typically include the spouse, family members, close friends, and charities. If the will maker has children under the age of 18, a guardian will need to be nominated in the will. The guardian is generally a relative or close friend who will assume the care of children in the event of death. There needs to be 2 independent witnesses present when the will maker signs the will. The witnesses should be over 18. They should not be family members or anyone who may benefit under the will. This would invalidate the will. What is probate? Probate is an order from the Supreme Court stating that the will has been proved to be the last valid will of the deceased. Probate allows the executor to collect and distribute the estate in accordance with the terms of the will. If the will is judged to be invalid, probate will not be granted. Remember, when preparing a will, always speak to your solicitor. We hope you enjoyed this brief presentation.